Deep Dive Podcast by the Boca Raton Tribune.
Welcome to the Deep Dive. If you're following Florida law changes, you've probably heard one thing: carrying firearms. It's all different now. Our mission today is, well, to cut through some of that noise, the confusing reports. We're digging into the sources you sent to give you the clear, actionable info on this major legal shift about open carry. And you can feel the buzz around this. I mean, Second Amendment folks are definitely celebrating big victory, but then there's also just a lot of confusion, especially about the exceptions, right? Where can you carry now, and where will it definitely get you into trouble? Okay, let's unpack this.
Yeah, we really have to, because the sources we're looking at, the court decision, the AG's guidance, law enforcement input, they show a landscape that, fundamentally changed overnight. But, and this is key, it's a change still governed by a whole web of existing rules and restrictions. So we're focusing on how this works right now, today, even with some legislative loose ends.
Okay, so let's start right at the beginning, the legal spark. It all comes from that Florida First District Court of Appeals case, McDaniels v. State. How big a deal was that specific ruling?
Oh, it was seismic. Yeah, because it basically struck down a law that had been in place for decades. The court ruled back on September 10th, 2025, said Florida's 1987 ban on openly carrying firearms, unconstitutional, didn't align with how higher courts are now interpreting the Second Amendment.
Yeah.
And the timeline is crucial here for understanding the immediate effect. The state had 15 days to appeal.
15 days.
Right, they didn't appeal. So come September 25th, 2025, the ruling stood, it became final. And that's the date the open carry ban effectively, vanished.
What was the core argument? Why did this law on the books since '87 suddenly fail a constitutional test? Was it just, catching up?
Pretty much, yeah. The main issue was that the 1987 law was just too broad. It didn't pass the constitutional tests courts use now for firearm laws, tests focusing on historical tradition and the text of the Second Amendment. Essentially, the court looked back and said, there's just no historical precedent, no tradition for such a sweeping blanket ban on open carry for otherwise law-abiding citizens. The old law banned it almost everywhere, with only very narrow exceptions. Too restrictive, the court found.
Okay, and this is where it gets really interesting, and maybe where a lot of the current confusion comes from that we need to clear up for you. The moment that ruling was final, Attorney General James Uthmeier acted fast. He put out guidance telling prosecutors, don't enforce the old ban.
Right.
But, and this is so important, the actual law, the words in the statute book that outlawed open carry, they're still there.
That's the legislative gap we mentioned. You can think of it like this. The court, the judicial branch, put a huge unconstitutional stamp on that law, made it dead letter, unenforceable. But only the legislature, the legislative branch, can actually go in and, physically erase those words from the Florida statutes.
So the law's technically on the books, but has no teeth.
Exactly. If someone were arrested just for violating that old open carry ban today, that case would get tossed out immediately. The AG's memo basically cemented that for prosecutors statewide. It does create this kind of legal limbo, though, which is why clear guidance for everyone, police, citizens, is so vital right now. The legislature just hasn't had the chance yet to sort of tidy up the paperwork.
Right. Okay. So the court ruling is the earthquake. The AG's memo is like the immediate stabilization effort. What's the new default rule then? What's the baseline now in Florida?
The new normal is, well, it sounds simple on the surface. Statewide rule.
Huh.
Open carry is now generally allowed in most public places. But the key condition is if the person is legally eligible to possess a firearm in the first place. So it basically brings open carry onto the same legal footing as concealed carry for those who qualify. The big change is just removing that automatic ban on having it visible.
But hearing that generally allowed in most public places, it could sound like anything goes now. And our sources really stress that's not the case. While the ban on open carry itself is gone, tons of restrictions about where you absolutely cannot have a gun, those specific locations, they're still very much in effect, firmly in place.
Yes. And that's critical information for everyone, whether you own a firearm or not. You absolutely need to know these boundaries.
Let's spend some time on these hard boundaries, these sensitive areas. The court's ruling didn't change these location-based rules at all.
Not one bit. So based on the sources, we pulled together a list. Places where firearms are still prohibited, doesn't matter if it's open carry or concealed.
Okay, let's group them. First up, education settings. Schools K through 12 and college or university campuses. Still gun-free zones? That seems consistent.
Very consistent priority there.
Yeah.
Then you've got government buildings and places related to civic functions, so courthouses, any official government building, and importantly, police stations, sheriff's offices. Sheriff Bradshaw pointed that specifically they count as government buildings.
Makes sense.
Also in that civic category, polling places. During voting, absolutely no firearms allowed, open or concealed.
Then there's travel and sort of large public gathering safety, airports, passenger terminals, still off limits unless you're law enforcement. That lines up with federal rules too, mostly.
Right. Travel security is strict. And finally, 2 types of places linked to public entertainment or where judgment might be impaired. Sporting events are generally restricted unless it's like a gun show or a shooting competition itself.
Okay.
And maybe the one people encounter most socially. Bars. Establishments whose main business is selling alcohol for consumption on site. No firearms allowed inside. Period.
That's a pretty extensive list. So the takeaway is clear. Yeah, you might be able legally to carry openly walking down a sidewalk or in a park now, but a whole lot of buildings and places you go every day are still completely off limits.
Absolutely. Location is rule number 1. Got to know where you are.
Mm-hmm.
Then there's rule number 2, which honestly might be even more critical now with open carry being visible. And that's about how you carry, your conduct, your responsibility.
Right. The new policy doesn't suddenly give you a pass on existing laws about behavior with a firearm.
No way. The sources are very clear here. You need to understand the difference between just legally, openly carrying and behaving in a way that's illegal or threatening.
Which Florida law already addresses.
Exactly. There's already a law in the books untouched by this ruling that makes it a crime to carry a firearm in a swarm. Let me get the wording right. A rude, careless, angry, or threatening manner.
Okay. Rude, careless, angry, or threatening. And the sources mention holsters specifically in this context.
Yes. The guidance strongly suggests, and common sense dictates, that carrying the firearm securely in a holster is key to showing responsible conduct. Helps avoid crossing that line into careless or threatening, if the gun is just tucked loosely in a waistband or someone's handling it nervously or gesturing with it. That's where you could easily run afoul of that existing conduct law, even if open carry itself is technically allowed.
Got it. Holstered seems like the practical advice there.
And we absolutely have to talk about private property. This seems to be a huge point of confusion, this court ruling. It applies to public spaces. It does not change the rights of private property owners.
So a shop owner, a restaurant owner, anyone with private property,
they still have the absolute right to ban firearms on their premises. Concealed or open carry, doesn't matter. If they say no guns, that's the rule on their property.
And if you walk into a place with a clear no gun sign or the owner asks you to leave because you're carrying, what happens then?
Your legal duty is to leave immediately. If you refuse. You're not covered by the new open carry policy. You can be arrested and charged with trespassing, plain and simple.
Trespassing, okay. That's clear. So private property rights remain unchanged.
Unchanged.
Now, to really get a feel for how this is playing out on the ground, we looked at what law enforcement is saying. Palm Beach County Sheriff Rick Bradshaw gave some interesting insights.
Yeah, what was fascinating from his perspective was that while this is a huge legal change, he indicated it doesn't fundamentally alter how his deputies approach situations in terms of safety. His quote was pretty direct. Deputies always assume everybody's armed until we find out they're not. So he basically said, look, this isn't going to drastically change how we interact with people from a safety standpoint.
That says a lot about the reality they face already. But he also touched on that line again, legal carry versus threatening conduct.
He did. He used a really vivid example to explain the conduct law. He said something like, a guy with an M16 walking down in the middle of a crowd, that's an issue because you're scaring people.
Okay, so it's not necessarily that the M16 itself is illegal to possess or openly carry in that public space now?
Right. It's the context, the manner. Walking through a crowd with a rifle like that inherently creates fear and panic. That's the threatening manner the law talks about, regardless of the rifle's legality on its own.
So that really highlights the shift. Just seeing a standard handgun openly carried isn't automatically illegal anymore.
Correct.
But how it's carried, is it meant to intimidate? Is it being handled carelessly? Is the weapon itself, like in Bradshaw's example, so out of place and alarming that it scares people?
Yeah.
That's where the conduct law kicks in.
Precisely. And Sheriff Bradshaw did confirm, while their core safety approach doesn't change, his deputies will be fully briefed on the new open carry rules. They'll be trained on enforcing those sensitive area restrictions and judging that conduct piece. Their job now involves even more judgment about context and intent, probably more than ever before.
So what does this all mean for you? If you're listening, what's the bottom line?
Okay, the main takeaway has a few parts. First, yes, Open carry by legally eligible people is now allowed in many public places in Florida because that old 1987 ban was struck down by the McDaniels court ruling. The simple act of displaying it isn't automatically illegal anymore. However, these are huge. However, this new freedom is tightly controlled by two big factors you absolutely have to remember. Factor 1, location, location, location. Those sensitive areas we listed, schools, government buildings, bars, airports, polling places, and so on, remain completely off limits. No guns there, non-negotiable.
Okay, location first.
Factor 2, conduct. How you carry matters immensely. You need to be responsible. The law still forbids carrying in a rude, careless, angry, or threatening manner. Using a holster is strongly advised.
Yeah.
And private businesses can still ban guns entirely and have you charged with trespassing if you refuse to leave.
So this court decision changed one big piece. The ban on just having a gun visible is gone, but all the other rules about sensitive places, about acting responsibly, about private property rights, they're all still firmly in place. It's like an expansion of rights, maybe, but definitely not an erasure of responsibility.
Exactly. It's not a free-for-all by any means. And, this brings up a really important point about what happens next. The legislature almost certainly has to step in.
Yeah.
We already mentioned that the old statute, the one banning open carry, is technically still printed in the law books. That needs to be cleaned up just to avoid confusion down the road.
Yeah.
Legislative housekeeping, basically. But maybe more significantly, think about that phrase, threatening manner. Now that open carry itself is legal, how will courts interpret that phrase going forward? Will having a handgun visible, maybe not even in a holster, in a public park, be considered threatening by itself? Or will require something more like yelling or pointing or aggressive moves?
That's a tricky line to define legally now.
It is, and figuring out exactly where that line falls, especially in different situations, that's likely going to be the focus of future court cases. That interpretation will really shape how this new policy actually works and how it's enforced in the years to come. That's something to watch.